today, guys, what I think we should talk about is defenses to FCRA actions. Okay, and what I'm talking about is the arguments of the defendant. So after we sue them, right, we know what the law is, and the law is pretty clear, and a lot of the time the violations of the law are extremely clear. And in fact, as we've said before, in contrast to other consumer actions, FCRA actions, Fair Credit Reporting Act actions, typically have paper documentation for everything. Okay, so you don't have a lot of that dispute of fact that you have. Did they say X or did they say Y? A lot of that stuff doesn't matter because we know exactly what happened from the dispute letter. We know what was said. It's all in writing. We have evidence of those dispute letters because we have certified copies of the mailing, and we have electronic files which substantiate what was said in those writings. And then oftentimes we can also obtain those writings from the defendant themselves through the discovery process. So we're not always dealing in a dispute of fact, or we're actually rarely dealing in a dispute of fact with FCRA actions. So in contrast to a standard lawsuit, I said X. No, you didn't, you said Y, right? Factual dispute. We can argue all day long about that, and that's many times what a defense comes down to in a standard lawsuit. FCRA differs because we know exactly what was said, and what we call that in laws, there's less of a factual dispute and more of a legal dispute at issue. Okay. The the consumer reporting agencies are extremely sophisticated companies. They've got tons of money for litigation, and they have carved out a defense under the law reliant on legal arguments versus factual arguments. Okay, so this, I would say, more than anywhere, the issues of standing and proper jurisdiction and procedural issues come into play in FCRA cases. And that, unfortunately, is why you see so many FCRA actions brought pro se by consumers, summarily dismissed by courts. Because these arguments have been going on for so long, and this area of law has developed for so long, that now Joe Schmo has very little ability in being successful with an FCRA case, even though that guy can often walk into court and say, this is exactly what was sent, and the law says X, and this is what happened to me. And there can be a little debate that that's exactly what happened, and the defendant can still get these cases thrown out. It's frustrating. It's extremely frustrating, and I think that the law has evolved the way that it has simply because the CRAs, the consumer reporting agencies, have had so many good attorneys on this for so long against pro se clients that you've seen case law versus statutory law develop in favor of these consumer reporting agencies. Okay, now let's talk about specifics. Okay, that's kind of your general overview, but let's talk about these specific defenses and how does somebody make a legal argument that they didn't actually violate the law or that the law somehow doesn't apply despite documentary evidence to the contrary. Okay? So the first thing that you'll see is standing defenses. Okay? Okay. And one of the big cases that hammered on this standing issue was Twomley. Why? Wow, my printing really is something to be desired. Anyway, Twomley. What did Twomley say? Twomley, and then there's another case, Iqbal, Iqbal v. Ashcroft, national defense case from years ago. And what do these cases say? Well, these cases say that a complaint needs to have pled plausible facts to state a case for relief in the courts. What does that mean? Or how is that different than the standard that was before? The standard before was simply a short and plain statement of the facts. So you could say, X happened and therefore I'm entitled to relief under Y, or under statute Y. This changed with Twombly. It wasn't just okay to say X happened. It has to be plausibly alleged. So therefore, I was standing at this corner on this date. The defendant was standing on that corner at this date. And at that point, the defendant shouted my name and said I was a criminal, and it was witnessed by Joe over here. Much more complicated versus the alternative, the previous standard, which was nothing more than a defendant yelled, Dave is a criminal, standing on the street corner. Totally different. You need to allege so many more facts. And you'll see these CRA defendants continue to argue, hey, there's not enough facts in this complaint. And therefore, it should be dismissed. They failed to state a claim under the Twombly standard or Iqbal standard, and therefore the case must be dismissed. It's extremely unfortunate that cases are dismissed for these pleading problems, but it occurs, and that's something you definitely need to be aware of. The second standing basis, they'll say, you know what, under Spokio is the case. Under Spokio, the plaintiff in this case, sure, we violated the law, 100%. We violated the law. We agree we violated the law. But the plaintiff can't bring a case in this court because under Spokio, they didn't actually suffer any harm. Believe it or not, that is a completely viable argument which will get a case dismissed. Despite the fact that the law, the black letter law, the law established by our Congress, specifically says, look, you violate the law, you are due statutory damages under the law in the amount, for example, and under the FCRA, of $1,000. So you've got a law, when you read it, you violate it, I'm entitled to $1,000. I think any normal person could say, hey, look, a problem on my credit report, that seems like it seems like an issue. I've obviously, this frustrates me. I obviously have suffered in some way from this, but should you not actually plead harm into your complaint will be dismissed under Spokio. It's a very, very frustrating process again. So what kind of arguments, let's talk further about specifics, and what kind of arguments do we typically see, what kind of Spokio arguments do we typically see these defendants making? I'll tell you what they say. They say, sure, there was an error on your credit report, and in fact, it was a bad error, right? It said that you were past due on this mortgage and you had defaulted on your car. In fact, we mixed up two files. Your file, which in your perfect credit rating, and then this other file we mixed up had all sorts of defaults on it, and it substantially lowered your credit score. But, we never published this report to anybody. So you didn't suffer any harm. We caught it. You caught it. You brought it to our attention. Sure, you sent a dispute letter. We sent it back as verified. But you know what? You didn't suffer any harm because you never applied for credit. You were never turned down for anything. And therefore, you don't have standing under Spokio. But other courts have held differently, number one. Number two, you will see a situation where they'll say, well, sure, it's all wrong, but you didn't actually suffer any harm. You didn't plead in your complaint that you suffered from, fear or anxiety or frustration or any of these things. It seems ridiculous that somebody needs to plead that, but nonetheless, apparently it's now required to, put a statement in there that were this not published, I suffered from, anxiety and frustration in having to remediate this process, and defendants' failure to follow established law. I think that their court is trying to turn us plead that kind of crap. I mean, obviously you're going to have a little frustration with it. I don't think you should have to, put that in there. But apparently you've got to also tell the court that the sun is going to come up tomorrow, or you may not have a case. It's a frustration. I think it's ridiculous, but again, very sophisticated defense lawyers, very sophisticated consumer reporting agencies spending tons of money on lawyers have carved this little hole out now, requiring this type of standing, or allegations of injury in fact. So those are two of the the defenses that you'll see on the front end. From a pleading perspective. Then later, as you get past, and typically we'll call these 12B6 motions. This is otherwise known as a motion to dismiss, MTD. Okay. Later, as discovery, remember from earlier lessons, we talk about how this is one of the first motions that they bring, and we've got, this is the complaint. Complaints over here, then we go to discovery. All right, then we go to many times pre-trial motions or post-discovery motions. Okay, and then we get over here to trial. Okay, so these motions are really brought at that complaint stage. Later we'll see other motions after the discovery, or between the discovery and pretrial stuff. And so in this area, you'll see a different argument coming from defendants. Okay, and so here at the summary judgment stage, or later stages as to arguments of damages, you will hear the defendant raise the argument that sure, we put somebody else's credit information on your credit report, and sure, that information was wrong. But here's the deal: you already had a crappy credit score. And therefore, you weren't damaged anyway. You had a low credit score to start with. We put additional stuff on there. You've still got a low credit score. This is particularly targeted towards low-income individuals, right? It is an attempt by these CRAs to target people of low economic means and not pay them the same amount of money that they might pay somebody who had a better credit report or who is of higher economic means. Groups are targeted by this ridiculous defense. But again, we've got sophisticated defense attorneys working for sophisticated clients, and they've developed this area to the point where they say, yeah, look, it was a minor difference. Another problem I think that you'll see, particularly for litigating these cases on a pro se basis or on behalf of an individual with lower economic means, is the no relative damages. Okay? And this argument, the responding to this argument, requires you to hire a expert witness. So they make these arguments and they bring in expert witnesses that say this person's credit score would never have been damaged. I'm an expert witness in scoring credit reports. And so somebody of low economic means is now required to hire an expert witness to simply get to get past this argument that, maybe even going back to Spokio, that they've had no damages because this expert says that there are no damages, and therefore, they don't have a case here, and it should be dismissed on summary judgment, maybe in some cases motion to dismiss. Absolutely. So the expert witnesses that I have engaged in this have gone for about $500 an hour. They are they're very expensive. They're also very knowledgeable, because we have to respond to essentially an organization with unlimited funds to litigate these cases. So and I'll say maybe like 300 to 500 an hour. And guess what? These guys don't work on contingency. This has to be paid. Okay. So luckily, you have guys like me out there who are willing who believe in our cases enough and are fronting this. But when you look at, and I'm speaking from a private attorney level, right? I think we're developing how we do this at Minnesota Legal Assistance, but specifically, when I'm doing these in private practice, I'm fronting a lot of this case, or this money right here, right? So I'm taking tremendous risk, and therefore, when we win a fee, it's not always as it seems, right? There's a lot to it. So that's something to always be cognizant of, as our group is working on projects, but also articulating that story to potential clients on hey, look, it's really important that you're not lying to us on about something, or that we're giving an honest, forthright story, because we're putting a lot of money and time and effort into these cases in order to bring them to fruition. So that is another hurdle that needs to be overcome in order for these cases to move forward. And then, after you go through all this, right? You go through your motion to dismiss and you go through your summary judgment. Those same arguments often will come up at the trial level, right? And those same arguments are made to a jury. And the jury doesn't a lot of the time have the oversight of like what went into this, how much money and time and effort has been taken to simply get before a jury. But those same arguments are made before the jury, and in an attempt to mitigate or lower any damages necessary, plaintiff prevails in court. So that's kind of the overview of many of the defenses that we see. Certainly there are factual defenses in FCRA cases, such as, look, the letter was never mailed, or we never received the letter, fact. I sent it, you didn't receive it, factual dispute, right? Was the letter actually sent would be that factual dispute. You don't often see those. I think we take great pains at Minnesota Legal Assistance to document when helping consumers. Should that consumer ever need to later take action against the CRA, we want to have that file clean. But that is also the reason that our credit side is working up those files and making sure that everything is documented, because this is the battle that we will see in the future. So to recap this real quick, right? We have motion to dismiss based on Twombly, not enough facts in the complaint, you did a poor job of pleading it. We have spokio, i.e. you didn't suffer any actual harm here, you simply just are trying to get your statutory damages. Then you see later more factually specific arguments, such as you had a crappy credit score to start with and you have a crappy credit score afterwards, and therefore you shouldn't be provided credit. Either way you would have been denied, and therefore you didn't actually suffer any harm. The necessity of bringing in expert witnesses and simply running the clock and trying to make this more expensive for a plaintiff to litigate the case, another defense strategy we see. And then certainly, then you get to the trial stage where those things are regurgitated. Those same arguments are. Now, a couple other things that I'll say about this process is throughout it you also see objections and feigned ignorance when examining witnesses during corporate witness depositions. I don't know if there's a policy or a procedure, and you might have a case that's very reliant and pointed to a specific lack of policy or procedure, and this witness will show up and have no idea, and they'll you'll have to stop it, and again they run the clock and attempt to frustrate the process as much as possible. But that only hopefully only serves them for so long before trial occurs. And keep in mind, the plaintiff bringing this case shouldn't be discouraged by all of these, because I think with a competent advocate and good facts, real facts, not made up stuff, real facts and a competent advocate, I'm confident that you can either get to a trial or to a settlement stage and actually hold these guys accountable. But again, you need to be cognizant of these arguments that you will hear throughout the process, as well as what your attorney is doing in litigating an FCRA case. So with that, I think that I'd like to really conclude the basic defenses that we see. We can certainly go into specifics as to individual claims, like what might be required under a lack of reasonable procedure claim versus perhaps a failure to investigate claim. What allegations need to be made to meet those Twombly or Iqbal standards? What might you see with regard to an argument, as far as harm goes, with specific claims? We can go into greater detail with that in future lessons, but this is just kind of the broad overview of the defenses that you will generally see in FCRA litigation. So thank you very much, and we look forward to seeing you.